Thank you, Madam Clerk. Good afternoon, folks. This is the Court of Criminal Appeals January session, afternoon docket. My name's Robert Wiedemeyer. I'm from Nashville, live in Nashville, Tennessee. To my right is Judge Robert Holloway, Jr. from Columbia, Tennessee. To my left, Judge Timothy Easter from Williamson County, Tennessee. We have several cases on the docket this afternoon. Each side gets 20 minutes to argue. If you're the appellant, you want to reserve part of that 20 minutes for rebuttal argument, please let us know before you start your argument and we'll keep up with that time for you. We have read the briefs on these cases, so we're familiar with your cases to that extent. The records will be assigned at the end of this session of court. I think, are there any preliminary matters before we start the cases?
No, Your Honor.
All right, Madam Clerk, if you'll call the first case on the afternoon docket, please.
Donald K. Moore, Jr. versus State of Tennessee.
All right, is this Ms. Hicks?
Yes, Your Honor.
Good afternoon.
Good afternoon, Your Honor. If it please the court, my name is Ardena Garth Hicks, and I'm representing the appellant in this matter, Donald K. Moore. I'd like to reserve 3 minutes for rebuttal, if I could.
Certainly, three minutes.
Yes. Your Honors, first of all, I would like to make sure that the court understands that I've been keeping up with what's been going on. This has been an issue from the time that, not so much an issue, but the petitions for a post-conviction relief were filed later in 23, and we were filing our brief in September of last year. And I did my reply brief in October of last year. And then the court in November ruled in another matter that was similar to this one, stating that Booker did not apply to consecutive sentencing. And I understand that court's ruling and would like to make the arguments that I make in the interest of justice at this time. Basically, as you stated, you've looked at our appellate brief, and I want to rely on that. I'd like to kind of turn a lot of my energies and efforts toward the reply brief, because there's some issues there that I'd like to make sure that we bring forth, and I'd at least like to make sure I put on the record. And if your honors have any questions, I would feel kindly answer to those questions that you might have. First of all, Mr. Moore is a juvenile offender who, at the time of when he was 17 years old, committed these charges that are here before you now. And he filed a post-conviction relief right a year after the Booker's decision was final. The court in Nashville, the trial court in Nashville, summarily dismissed those petitions stating that Booker did not apply to consecutive sentences. I did attach a copy of that order to the reply brief, and the court relied on a case, not a Tennessee case, but a case out of Missouri, and I think the case was like 2008. So it's a little pre-Booker, and it specifically talks about consecutive sentencing, but not about juvenile offenders who've committed homicides. So therefore, we would like, that's part of our argument that says in the interest of justice, there needs to be a more expansive view of protecting Mr. Moore's Eighth Amendment rights against cruel and unusual treatment because of the sentencing. Now, he did have his custodial hearing with the Board of Paroles, and I was representing him in that matter also. And it's kind of out there pending at this time, and they haven't taken any, he wasn't granted at his first hearing, so it should be coming up in about I think it's supposed to be 3 years from the date of the decision. But at the same time, we want to say that Booker, since Booker had its impact on a person And the court said that it was unconstitutional to receive, like in the cases that had the death penalty, 51 years was unconstitutional for a juvenile where his youth wasn't taken into consideration. When it comes to sentencing, youth does matter. And that's kind of been the standing of Booker all along. And when you try to narrow it and make it only apply to homicide convictions, and it doesn't relate to all sentencing for those juvenile homicide defendants, there does need to be a sense of justice and right standing in those matters. We think that the state's position, where they want to rely on saying that the statutory rules of the Booker matter doesn't apply to Mr. Moore, we would like to say that he is in that protected class of people that Booker was originally thought to help. And one of the things that it did bring is the thought that there had to be a broader application of what Booker meant when it kept saying youth matters, youth matters, youth matters everywhere. When a person is a juvenile homicide defendant, youth matters in what the sentencing should be, what the court is going to rely on is what's going to be just punishment, and those factors kind of stay the same. And since Tennessee's statutory, consecutive statutory scheme does not involve youth, that means that when defendants like Mr. Moore were sentenced and got some relief under Booker through the parole hearing that they were able to, the custodial parole hearing they were able to get, you still have to look at the fact that because Mr. Moore was 17 at the time his trial happened, he did get consecutive sentencing at that time because I think 2 of his sentences were not homicide related, but were consecutive to the homicide. Therefore, the Eighth Amendment protections that should be allowed to juvenile homicide defendants should be applied even to consecutive sentencing in that matter.
Hicks,
Yes.
Let me ask you a question.
Yes.
Appreciate your argument, and I think we're starting to see some of these type of cases involving the Booker Supreme Court ruling. And I recently had one, and what stands out in my mind was that, and I want to paraphrase because I don't have it written down, but the way I read Booker, the Supreme Court stated that it only applied to situations where a minor defendant was automatically sentenced to life for first-degree murder. And the reasons that it sort of said that is because in all other cases, there is a sentencing hearing where the sentencing judge can take into consideration the defendant's age. Okay, so that's sort of my preference. And so if I'm right, and that's what Booker says, how can this court get around that? I understand how the Supreme Court can, but how can this court, as an inferior court, get around that?
Well, I think that's part of what we were asking for here is not for this court to actually have to deal with those issues. It should be held at a hearing at the lower court, and that's why we're also asking for it to be remanded. And this is something that, if it's my understanding, even though that's the holding in Booker, you've got the Eighth Amendment applications that's even broader than the specific holding. And so that would be my position, is that even though it does specifically talk about, and I think what I want to make sure I'm saying, that was the holding. They wanted to they didn't say Booker applied to every criminal defendant. They said, you've got to be a juvenile at that time. It has to be a homicide involved, and that you had to be sentenced to a life sentence. And Mr. Moore had that life sentence.
But the key word to me, the book was automatically sentenced. And that's what, seemed.
And I think, but the response, and I was trying to make sure, because I think I I think the situation and position that I would like to argue is that that's all about discretion. And when you're dealing with the Eighth Amendment, when I was practicing in some of the criminal courts in Chattanooga, the court could have discretion, but they didn't have discretion to actually think about the power of Booker, the protection of Booker, the Eighth Amendment out there for a juvenile who's been transferred to adult court, supposedly having a evaluation of his mental faculties to see what, if he knows the difference between right and wrong. But then nobody's looking at that time, there was no demand that says, as it now says in Booker, it should be looked at all times, and it's not something that should be discretionary, should be mandatory. But I think that's part of the issue, is that even if you're dealing with discretion doesn't amount to the Eighth Amendment. It's not a constitutional guarantee, and it's not something that's even protected at that time. Back when these cases were going through in the 90s, you couldn't even bring up mitigating factors of youth unless you were actually in trial and there was a sentencing hearing. Now, according to the way youth matters, now you should be able to bring that argument in as an Eighth Amendment argument that brings in the family, all those things that they talked about in Booker, the drug issues of the defendant, the family situation of the defendant, what's going on in their lifestyle, and ACEs and all these other things that everybody kind of thinks of now. Back when Mr. Moore was dealing with his case, there was no discretion, there was no thinking about that, and you normally couldn't even get to it until after you were actually having a trial. There was no agreement or argument at that time.
Are
Yes.
those issues brought before the parole board during the individualized parole hearing?
It depends. I had two of these cases, and it depends upon the parole board, the board member who's listening. I had one member who really got into it and asked questions. Even you can tell there have been some times when some of the defendants want to say the right thing to the parole board, but Booker says, no, you get to bring up everything. You should say how you feel, when your dad lost his job and mom, was an alcoholic. But I had another parole officer that just said, defendant was 17 at the time of the incident, and then she went on to read everything that had happened as far as the offense, but nothing about youth matters.
And so what, these hearings, I've only been involved in one, what they can then do if they want to is say, you get out after 20 years or something like that. Mm-hmm. Is that correct?
Or they tell you, I had one where the person was able to get out, I think it was like 6 months later. So and I think it just kind of depends, but one of the things that has happened that I've been really excited about is that there's been one person that's been involved in criminal justice reform, and they said that a lot of changes that are going to happen, it's going to have to come from the prisoners themselves. And Mr. Booker, when we were preparing for his parole hearing, he had about over 100 pages of documents that we were able to present to the parole board. We would have loved to have had that opportunity, and I think that's what we were asking for. We didn't get a chance to go to the court and say, this is what was happening when he was 17. This is what's happening now that he's been in custody. There's been some things that say youth matters, and so the court could do and say what it wanted to do, but it dismissed those cases just because of the consecutive sentencing not applying. Okay. Any other questions? Well, I like I said, I would like to rely on what's in the reply brief at that time, and I'll be glad to respond to the state as they make their argument.
And were you appointed?
No, this one is pro bono.
I was just going to say, thank you for your,
I
thank you pro bono for that.
Well, the thing that I'd like to add is that I had the honor of being the Hamilton County Public Defender for 25 years, and always ended things right at the Supreme Court level. So this is exciting to be on this side to see, just how it just doesn't stop at the conviction. There are other things that we can argue about. And this has been a book learning piece for me, so thank you very much.
Thank you for taking the case.
Hello again, Your Honors. Alan Groves on behalf of the state. Donald Moore is serving a life sentence for a murder he committed when he was 17 years old. He's also serving consecutive sentences for 2 other violent felonies that he committed around the same time. After the Supreme Court decided Booker, Moore did receive a custodial parole hearing because he had received an automatic life sentence and had served at least 25 years in prison, but parole was denied. So then he sought post-conviction relief under Booker from the trial court's imposition of the consecutive sentences in these 2 cases. But the post-conviction court summarily dismissed the petitions. This court should affirm for 2 reasons. First, the only issue Moore actually presents in his statement of the issues is whether the post-conviction court erred by summarily dismissing the petitions as untimely. But the record clearly shows that the court actually found that the petitions were timely because they were filed within 1 year of Booker, and instead the court dismissed them for failing to state a colorable claim. And Moore technically waived that issue because even though it's argued in the brief, it's not outlined in the statement of the issues. But even if the court were to address that on the merits, as Ms. Hicks acknowledged this morning, this court's recent decision in Mallard versus State, Judge Holloway, I think you authored that opinion, which you alluded to earlier. The court pretty unequivocally held that Booker just doesn't apply to consecutive sentencing. And so even if the court were to address the colorable claim issue on the merits, it should affirm for that reason. So first I want to just spend a second talking about timeliness because that was referenced several times in the petitioner's brief. And I want to just clarify that issue for the court. The post-conviction court held that the petitions were timely because even though they're filed outside of that 1 year statute of limitations for post-conviction petitions, there's this statutory exception for if your claim is based upon a final ruling of an appellate court that's establishing a new constitutional right that's retroactive. If you file within 1 year of that decision, then it's an exception to the 1 year statute of limitations. And the state believes that this petition is timely because the petition was filed within 1 year of Booker. And even though we're saying Booker doesn't apply here, the claim is based upon Booker. And so I did want to point that out because the court's decision in Mallard, which was just released a couple months ago, which presents the same exact issue, it actually affirmed, but it said that because Booker didn't apply, the petitions were untimely. And I think that might have been because the post-conviction court in that case had made a ruling that they were untimely, and the state kind of briefed it that way to defend the court's judgment. But I think it's best to keep those 2 inquiries separate for purposes of future cases, that timeliness really relates to whether your claim is based upon a case that's establishing a new right that's retroactive. So if someone's alleging that Booker requires relief and they file within 1 year of Booker, it's going to be timely. They're just automatically going to fail to state a colorable claim if Booker doesn't in fact apply. And so for practical purposes, you reach the same result. You get a summary dismissal of the petition before an evidentiary hearing. But I just wanted to clarify that for the court because I do think the court should be precise about whether the petition is timely versus whether it fails to state a colorable claim. And as Ms. Hicks mentioned, this court did directly address this issue in Mallard, and we think the court's reasoning in Mallard is sound. Booker's holding is quite narrow. It really only applies to juvenile homicide offenders who receive that automatic life sentence, as Your Honors mentioned. And the court's reason for that was really twofold. One was the automatic nature of the life sentence. There's just no discretion for trial courts to consider youth. And then the other aspect of it that sometimes gets overlooked is just that Tennessee's 51-year incarceration length was a lot longer than some other states. So there was kind of those 2 independent facts that drove the court to decide that that violates the 8th Amendment in that very specific circumstance. But it really just has nothing to say about consecutive sentencing. And to the extent it does talk about consecutive sentencing in Booker, it actually supports the state's argument here because Booker received another sentence that was concurrent. It was an especially aggravated robbery. And in discussing the procedural history of the case, the Supreme Court was contrasting how the original trial court didn't have discretion when imposing the automatic life sentence, but it did have discretion to consider youth when imposing that concurrent, especially aggravated robbery sentence. So it said, at that hearing, the sentencing hearing, the trial court was allowed to consider as a mitigating factor whether Mr. Booker lacked substantial judgment in committing the offense because of his youth, citing those statutory mitigating factors when we're looking at the length of the sentence, which also relates to consecutive sentencing. Even though it's not one of the enumerated consecutive sentencing factors, we know that sentencing is kind of holistic in nature, and you have to consider the length of the sentence and the aggregate length of the sentence when you're aligning multiple sentences. So when you're in that original sentencing posture, even Booker acknowledges the trial court has a discretion there to consider youth. To the extent we want to look at Booker for the information about how we should think about consecutive sentencing for juveniles, it actually still supports the state's position here that the Eighth Amendment's not implicated. And I know Ms. Hicks has mentioned a few times that the trial court here didn't have the opportunity to consider youth, and that it didn't consider youth, and maybe more evidence could have been produced. But as Judge Holloway noted in the Mallard decision, when the appellate record doesn't have the sentencing hearing transcript, we really just don't know in this procedural posture what was presented at sentencing. We don't know what Mr. Moore presented to the sentencing court with regard to his youth. So to the extent we're trying to make arguments about what the trial court considered or could have considered with respect to youth, in this case, that's just not properly before the court because we don't have an appellate record with a transcript of that sentencing hearing. But for the reasons discussed in Mallard, even if we had that record and that transcript, Booker still wouldn't do anything for Mr. Moore here because the holding is so limited. I do think, since, as was pointed out, the Mallard case came out in November, I don't think either party was able to address it in the brief. So if it's helpful to the court, I can provide a letter of supplemental authority to that effect so we can get that before the court in the record. But if there's no further questions for me, we just ask that you would affirm the judgment of the post-conviction court. Thank you.
We are still asking that the matter be rescinded to the trial court for a hearing and a culpable claim order be issued. With regards to the record with regards to youth being argued and things of that matter, Mr. Moore's case was different than Mr. Mallard's case because I think in the Mallard case there was no immediate appeal that happened in that case. Therefore, the records were not there as far as what happened in his case. With regards to Mr. Moore's case, he did appeal his matters up, as I think one of his convictions was for felony murder, and it came back second degree. So there was a record, and there were things that were discussed, and he did have sentencing hearings at that time. And as I was stating, what normally happened is that back when Mr. Moore was a juvenile homicide defendant, there was no protection saying youth mattered. So that is why we were saying, and even if he had appealed some of those issues, the Booker didn't exist at that time. So therefore, no one was looking at those things. I think there may be even a part in the reply brief where I did describe what happened in a Rule 12 that was related to Mr. Moore's matter, and it did say there was some section about youth in there, and there would be an NA in there, not applicable. And if someone took the time, it wasn't totally empty, but it did say those things, and we did attach that to the brief.
So let me see. I
Yes.
think Judge Holloway asked you this question, and you may have answered it, and I just missed it. But Mr. Moore did receive an individualized parole hearing?
Yes, he did.
He did.
Yes.
And was the youth piece presented to the parole, at that parole hearing?
It was presented to the board during the hearing, but when the board member was reviewing the facts and asking questions and inquiring, all she asked about was the age of the defendant at the time of the incident. She mentioned that he was 17 and said nothing else after that. There was nothing about
So
his youth.
you take from that then, she did not consider his youth?
It was totally different than the other parole board member who was a former sheriff. And he asked a lot of questions that I thought I was gonna have to make sure I put on the record for the person I was representing at the time. But with Mr. Moore, it was just, you were 17 at the time of this incident. And then she proceeded to talk about the crimes and what happened. Thank you. Thank you.
All right, thank you.
And with warm weather to everyone, I hope you don't mind if my husband and I excuse ourselves.
No.
We're gonna hit the road back to Chattanooga.
Good to have you here. I don't think you came before the court.
Drive safely.
We shall.
Call the next case, please.
State of Tennessee versus